Good morning and afternoon, everyone. Thank you so much for joining us for today's webinar, Worth the Paper They're Written On, Non-Competition and Non-Solicitation Covenants in the Workplace. While I introduce myself and our speakers, please see the information slide that's on your screen. I'd like to draw your attention to the survey piece in particular. We really value your feedback on our sessions, and so we encourage you to fill out the survey before you log out of the webinar today. We're also happy to announce that we're debuting an automatic CPD certification process at the end of the webinar. So at the end of the presentation, we'll have two options for you to automatically receive your Ontario or Quebec CPD certificates. A QR code will appear on the screen, or you can use the link that's been added to the audience chat. My name's Elizabeth Reid, and I'm a partner in Fasken's Vancouver office and a member of the Labour, Employment and Human Rights Practice Group. Within my practice, I help clients navigate the everyday and sometimes not so everyday issues that arise in the workplace, as well as represent clients at mediation and in the courts and administrative tribunals. I've represented clients at all levels of court in British Columbia and in front of the provincial and federal human rights and employment standards tribunals. It's my great pleasure to introduce to you my Labour, Employment and Human Rights colleagues who have joined us for today's session as well. I have with me Anthony Panacci. Anthony is a partner in our Toronto office, and he represents unionized and non-unionized employers in a variety of industries, including finance, telecommunications, education, transportation, and the manufacturing sectors. Also with me today is Matt Allard, who is an associate in our Vancouver office. In Matthew's practice, he handles wrongful dismissal actions, grievances, collective agreement interpretation disputes, disciplinary matters, and human rights issues. Now, on to our presentation. Today, we're going to give you a refresher on the legal principles that apply to restrictive covenants and share with you some of the recent case law. We'll then look at trends across Canada and the USA and go over some of the most common enforcement mechanisms. At the end of our prepared remarks, we've also left some time for your questions. So if you do have any, please submit them through the webinar portal. Now I'd like to turn it over to Matt to start off with our refresher on the basic legal principles that are applicable to this area of the law. Over to you, Matt.
Thanks, Elizabeth. So everyone, please bear with me. This is going to be the driest portion of the presentation. I'm going to take us through the discussion around the general principles applicable to restrictive covenants in the employment context. If we could, so starting with what is a restrictive covenant? A restrictive covenant is an agreement restricting a person giving the covenant from taking certain actions. During the course of employment, an employee is in position to acquire in-depth knowledge of the employer's business, of their operational methods, and forming strong relationships with the employer's clients. A restrictive covenant can minimize the harm that could be caused if the employee decides to use or disclose that information or use those relationships that they form to the detriment of the employer or to the personal benefit of the employee. We can see that restrictive covenants are sometimes just a term in an employment agreement. They're sometimes part of a separate agreement, or they're an element or component of the sale of a business. There's also a variety of different restrictive covenants that we can see in the employment context. Today, we're focusing specifically on two: non-competition and non-compete, and non-solicit, sorry. Next slide, please. So what is a non-compete? A non-compete typically prohibits an employee from starting a business, which is competitive to the employer, or from accepting work or becoming an employee of a business that is competitive to the former employer. Next slide, please. What about non-solicit? A non-solicit typically prohibits an employee from soliciting the clients, customers, employees, and any others with whom the employer has had business dealings. Next slide, please. So when courts are considering the enforceability of restrictive covenants, the starting point is the presumption that the restrictive covenants are void and unenforceable as they are restraints of trade. You'll hear as we go through the case law and through these principles that they're particularly difficult to enforce, and that's in large part due to this presumption. The Supreme Court of Canada has said that restrictive covenants give rise to a tension between the concept of freedom to contract and public policy considerations against restraints of trade. Now, the presumption that restrictive covenants are void and unenforceable is a presumption only. That presumption is rebuttable by evidence of facts and circumstances showing that the restrictive covenant is reasonable and that it goes no further than is necessary to protect the rights of the employer, which they are entitled to protect, and which does not unduly restrain the employee from making use of their skill and talents. The onus for rebutting the presumption that the restrictive covenant is unenforceable is on the party who is seeking to enforce the covenant, which typically is the employer. Next slide, please. So now I'm going to take us through the basic components of the tests that is applied by Canadian courts in determining whether non-competes and non-solicits are considered to be enforceable. Next slide, please. Determining to be enforceable, the restrictive covenant has to be a reasonable balance between the parties and the public interest of avoiding restraint of trade. The assessment of what is reasonable is made based on when the covenant was entered into and not at the time of the termination of the employee. To be reasonable, the restrictive covenant must be all of the following. It has to be clear and unambiguous. It has to be linked to the protection of the employer's legitimate proprietary interest. It has to be reasonable with reference to the public interest. And there must be reasonableness between the parties, which means that it must be reasonable in terms of its geographic scope, its temporal scope, and the activities which are being restricted in the clause. It also must be reasonable in all of the surrounding circumstances. Now, over the next number of slides, we're going to go into some more detail about each of these components of the tests that are applied by the Canadian courts. Next slide, please. A restrictive covenant may only be used where it's reasonable to protect the employer's legitimate proprietary interests. And what this means is that an employer cannot use a restrictive covenant to improve their competitive position in the marketplace or for the sole purpose of preventing the employee from competing with the employer elsewhere. An employer does not have a proprietary interest in an employee's professional skill or experience, even where the employee developed that skill and experience with the employer. The proprietary interests that are reasonable for an employer to protect are client relationships, goodwill, trade connections, and confidential information, including trade secrets, marketing strategies, and pricing structures. Next slide, please. So when looking at the reasonableness between the parties and what was agreed to, as I mentioned, the party who is relying and trying to enforce the covenant bears the onus of establishing its reasonableness. And so when we're looking at what's reasonable between the parties, as I mentioned, the main components of that are geographic and temporal scope and the activities that are being restricted. Typically, I would say that this component of the test, along with we'll look at later the requirement to be clear and unambiguous, are the elements where these cases typically will turn. So the goal of a restrictive covenant is to provide the employer with a reasonable period of time during which it can secure or reestablish its relationship with its customers. The temporal scope of the non-compete or non-solicit must be limited to only what is adequate to achieve that purpose. The more vulnerable the employer is at the time of an employee's termination, the longer the period of time over which this restriction will be tolerated. And typically, the vulnerability is assessed based upon the employee's position within the organization and their duties and responsibilities. Courts have more commonly upheld restrictions in non-compete and non-solicit clauses in the range of 6 to 12 months and much less commonly up to 24 months. Any non-compete or non-solicit has to also be reasonable in terms of its geographic scope. When drafting these clauses, the smaller and more narrow the geographic scope, the more likely it is to be considered reasonable and enforceable. If the geographic area is larger than what is reasonably required to protect the employer's legitimate business interest, the entire clause will be considered unenforceable. In particular, with respect to non-competition clauses, when they do not contain a geographic limit, they're going to be considered prima facie unenforceable. An employer doesn't have a legitimate interest in prohibiting activities where it doesn't carry on operations. In respect to non-solicit clauses, the absence of a geographic limitation is not necessarily fatal, provided that the remainder of the clause is strictly limited to solicitation rather than competition, and it's otherwise narrowly and clearly defined. With respect to the activities and scope of business being restricted in the clause, that should be limited to only what is reasonably necessary to protect the employer's interests. As a general rule, courts are more likely to uphold a solicitation clause, which is tailored to the particular clients or customers that the employee can identify and has actually managed or serviced, as opposed to a general restriction on all clients or potential clients of the employer. A solicitation clause is more likely to be upheld if it's tailored to those that were still the employer's clients or customers at the time of the employee's termination or at the time of the solicitation, as opposed to clients that had not done business with the employer for many years or who are no longer in a business relationship with the employer before any solicitation occurs. Solicitation clauses will be more likely to be upheld if they're tailored to clients that were not pre-existing clients belonging to the employee. And finally, they're more likely to be upheld if they're tailored to active solicitation rather than mere contact with the client. An active solicitation generally means some positive or overt act, step, or conduct. When thinking about non-competition clauses, it's important to define as narrowly as possible the nature of your business so that the scope of the businesses which are competitive to your business are restricted to only what are necessary. We'll sometimes see employers trying to include in their non-competition clauses restrictions around future fields of business. However, as I mentioned, because the reasonableness of the covenants are assessed at the time of the signing of those agreements rather than at the time of termination, employers will have a really difficult time restricting competition in business field that didn't exist at the time of hiring and were developed only during the course of an employee's employment. Next slide, please. Courts also have to be satisfied that the restrictive covenant, even if it's reasonable between the parties and those other elements of geographic and temporal scope and the activities that are restricted, courts have to also be satisfied that it's reasonable with respect to the public interest. Public interest requires that employees are free to work in their chosen profession and are entitled to use their work skills and abilities to make a living. I had mentioned that when establishing the reasonableness of the agreement between the parties, the onus is on the party trying to rely on that clause. However, once that has been established, the onus for attacking the public interest is on the party who's trying to establish the unenforceability of the restrictive covenant. And similar to the reasonableness of the agreement between the parties, the reasonableness of the restrictive covenant with reference to the public interest is also determined at the time the covenant was given. Next slide, please. Courts are also going to look, when they're determining the reasonableness of and enforceability of the restrictive covenant, they're going to consider all the surrounding circumstances. And so this means they're going to look at the nature of the work that was performed by the employee, the employee's role at the organization, the nature of the restrictive covenant, and meaning whether it was a non-solicitation or a non-compete, and the context and other terms of the employment agreement. Next slide, please. I mentioned that one of these restrictive covenants can be seen either in employment agreements themselves or as a separate agreement, and they also may form part of a sale of business transaction. The case law has drawn a significant distinction between a restrictive covenant that is found within an employment agreement or within the context of an employment relationship, and one that is given as part of the sale of a business by the vendor. So in the case of the sale of a business, the employee will have received payment for selling the business and negotiated the restrictive covenant, presumably without there being a significant power imbalance. And as a result, courts will generally assess and analyze those restrictive covenants with less rigorous scrutiny than they would in the normal course of an employment relationship. Courts will view the restrictive covenants found within an employment agreement and an employment relationship with more scrutiny because of the presumption that there's a significant power imbalance between the parties. Next slide, please. And so, as I mentioned, one of the other very key components to this legal test that courts are considering is a lack of ambiguity. The restrictive covenant, the drafting of the restrictive covenant has to be clear and unambiguous to be enforceable. If the clause is ambiguous, it can't be considered reasonable and the courts won't enforce it. Sort of a general rule of thumb to think about is the person against whom the clause is going to be enforced, being the employee, has to know precisely what they are required to do or what they must not do in order to comply with that clause. Courts are going to look to the specific language that was used in the clause. And so while the context is important when they're considering ambiguity, the language of the clause is going to be paramount. Courts will consider a clause to be ambiguous if it's drafted in a way that is capable of multiple reasonable interpretations. If it could be interpreted in a way that's overly broad in terms of its geographic or temporal scope or the activities that it's attempting to restrict. And it'll also be considered overly broad or ambiguous, if there are multiple inconsistent definitions within the clause. So it's important to review and ensure that the clause is consistent in how terms and terms are defined within. And so to sum that up, if it's impossible for an employee to predict when they're breaching a restrictive covenant, a court will find that ambiguous and unenforceable. So turning this over to addressing some recent case law.
Hey, back to me. I think so. Thank you so much for that, Matt, for your overview of those basic legal principles. So now that we're all refreshed on those, let's have a look at some of the recent case law in this area to see how those are being applied by the courts. And we're going to look at 4 cases in some depth, 3 from our Canadian appellate courts and 1 from the trial court here in British Columbia. I've also included in the slides a brief description of 2 other recent cases for your reference if you want some homework and would like to look into this a little bit more. For our friends in Quebec, there are no new appellate cases from Quebec in this area over the last sort of 3 to 4 years. So the trends are being set in the other appellate courts for now. For each of the cases, I've started with a slide that outlines the actual language of the restrictive covenant that was at issue. And when you look at them, I encourage you to think about sort of whether you think that language might be enforceable or not. So that takes us to our first case, which is M&P Drug Mart Inc. and Norton. This is a 2022 decision from the Ontario Court of Appeal. And the case involved an application for a declaration that the restrictive covenant at issue had been breached and for an order directing a trial on the issue of damages. So let's start by looking at the language of this restrictive covenant, which you can see up on the screen there. The employee agrees that during the employee's employment with the company and during the 1-year period following the termination, for any reason whatsoever, the employee will not carry on, be engaged in, concerned with, interested in, directly or indirectly, any undertaking involving any business the same as, similar to, or competitive with the business within a 15-kilometer radius of this specific location on Main Street in Huntsville. So that's the covenant that M&P was trying to uphold. And details matter. So the facts of this case were as follows. Mr. Norton started his employment as a pharmacy manager with M&P Drug Mart in 2014. And he had a written employment agreement, which he actually negotiated with the assistance of his own independent legal counsel. So he knew what he was getting into. And in addition to the covenant, the agreement also included standard terms acknowledging that the non-competition covenant was necessary for the protection of M&P's legitimate business interests, those legitimate proprietary interests that Matt was telling you about, and that was reasonable in the circumstances. Now, about 6 years later, Mr. Norton resigned from M&P, and he immediately began working as a pharmacist for a pharmacy that was only 3 kilometers away. And you'll recall that the restrictive covenant prohibited competition within a 15-kilometer radius. If we could just have the next slide there. So M&P was understandably upset given that they had what they had negotiated, and it applied to court to enforce the non-competition clause. Now, this is an Ontario case, so it's very important to note that the events at issue in this case occurred before Ontario's Working for Workers Act, which you're going to hear about from Anthony a little later on. So as short, that new act would have changed the analysis here. But in this particular case, the usual legal principles applied, and so there was nothing improper about M&P trying to restrict Mr. Norton's activities. The court struck down the clause at trial, and then M&P appealed, and the decision to strike it down was upheld on appeal. So let's have a look at the next slide to see why that happened. Oh, okay, a couple more here. One more forward, please. There we go. All right, sorry, I lied, one back. So M&P argued that the clause was intended only to restrict Mr. Norton from working as a pharmacist in the pharmacy. But what was fatal to their argument was that the language wasn't drafted that way. The court found that the covenant was ambiguous and overbroad. In particular, it prohibited Mr. Norton from being concerned, even indirectly, with an undertaking involving a business that might be similar to the drugstore. And that went too far because it was going to prohibit him from working in positions which clearly weren't going to pose a threat to the pharmacy. So, for example, that would stop him from working as a meat cutter in the deli department of a supermarket if that supermarket also included a pharmacy. So it was also unclear whether the clause only prohibited working with businesses that dispense prescriptions or whether it extended to any business that sold the kind of over-the-counter drugs, cosmetics, greeting cards, and similar kinds of things, which were sold by the pharmacy, by the drugstore, but also are regularly sold by convenience stores, your local 7-Eleven, Walmart, Superstore, all of those kinds of places as well. And again, if Mr. Norton had started working as a salesperson in one of those places, even if he wasn't working as a pharmacist, that was really unlikely to have any substantial impact on M&P's business. But there was a risk that kind of activity could have been caught by this covenant. And as such, the clause prohibited more than was needed to protect M&P's legitimate business interests. Now, while it was really clear from the negotiating history that M&P had wanted to stop Mr. Norton from doing exactly what he did, unfortunately, the actual covenant wasn't drafted in such a restricted manner, and the court wasn't prepared to rewrite those contractual terms. So what's our takeaway from this Norton case? That essentially, it's always apply the supermarket test when you're drafting or analyzing restrictive covenants. You need to think about ways that your business might overlap with other common businesses, and also consider what specific role or activity are you trying to prevent the employee from doing to make sure that you don't overreach. For example, the court in M&P actually suggested that it might have upheld the covenant if it had only restricted Mr. Norton from acting as a pharmacist for a pharmacy or in a store that included a pharmacy. But as it was, the covenant was overbroad and was struck down for that reason. So that takes us to our next case, which is the EF Institute for Cultural Exchange Limited and World Strides Canada. And again, we'll start by looking at the language of the restrictive covenant that was at issue. And here we have a covenant that says, for a period of 1 year following the termination of the employee's employment with the company, the employee will not directly or indirectly interfere in any way with the employment relationship between any person employed by EF at the date of the termination of the employee's employment and EF. And the other thing they were not to do was to engage or participate in or in any way render services or assistance to any business that competes directly with any product or service that the employee participated, engaged in, or had confidential knowledge of during the employee's employment with the company. So that's the covenant that we're looking at. And the facts of the case are set out on our next slide. The president of EF, Mr. Conklin, who became a defendant in this case, was dismissed without cause. He entered into a severance agreement, and that's where this restrictive covenant was found. So the covenant started on September 30th of 2014, and it ran for a period of 1 year. And as part of his severance agreement, he received 2 very large severance payments. The first was payable upon signing the severance agreement, and the second was payable right at the end of the non-competition period. So the non-competition period ends, and the very next day, he joins EF's primary competitor, World Strides. That was also, of course, the day after EF had paid him the second of his very large severance payments. So despite the fact that Mr. Conklin had held off joining World Strides until after the covenant had expired, EF was still quite concerned. And there were a few things that, they told the courts were of concern to them. The first was that during the non-competition period, Mr. Conklin had handed out his resume. And in highlighting his achievements, they felt that it had referred to information which EF felt was confidential. In particular, the resume said that he'd been responsible for an annual growth rate in revenue of more than 10% from 2005 to 2014. And it said that he'd improved the reduction of employee turnover from 30% to less than 20%. And EF felt that, disclosing this information to a competitor, constituted misuse of confidential information and essentially assistance to the competitor. Of course, he had also interviewed and negotiated his employment contract with World Strides. Those things don't happen in just one day. So it was pretty clear that that had been in the works for a little bit of a period before the covenant expired. During the non-competition period, he had also recommended that World Strides consider some particular office space that he was aware of. And he also told an EF employee who was being terminated that her severance package to him looked standard. So that's all he said, but he did sort of review this severance package for an EF employee and said, well, I think that looks pretty standard. Now, EF decided to take a very, very aggressive approach right at the outset. Their initial demand was for a total of $10 million, and they were claiming $5 million each from Mr. Conklin and from World Strides. It started a lawsuit and applied for interim and interlocutory injunctions, within weeks of Mr. Conklin joining World Strides. And their claim, they sort of threw everything they could think of at the claim: breach of contract with respect to this restrictive covenant, breach of confidence, breach of fiduciary duty, and a number of other claims as well. But as the case progressed, it became clear that the kind of oomph of the claim was just not there. The claims were reduced to closer to $300,000 and then started to decrease even from there. And the court described EF's case as dwindling and ultimately described it as a corporate grudge match that does not deserve to be prolonged further. Eventually, after a number of years of litigation, World Strides decided it had had enough and it just wanted things over and done with. And World Strides, as the defendant, actually applied for summary judgment. And World Strides was, in fact, so confident in its case that it didn't even challenge the enforceability of the covenant. So both parties went into that summary judgment application saying, okay, we'll accept that that covenant might be enforceable. We won't even argue about that. All we need you to do, court, is determine whether that covenant has been breached. And the court found that any communication between Conklin and World Strides about EF was really what they described as de minimis. And any exchange of information was non-sensitive information that would have had little, if any, impact on the competition between EF and World Strides. Essentially, they said, Mr. Conklin's recommendation about office space was really an offhand remark, akin to, why don't you check out Bentall 2 on Bay Street, and was inconsequential. There was also nothing improper about him interviewing with World Strides, because employees are certainly entitled to look for other employment during their non-competition period. In looking at, the highlights of achievements on his resume, what was sort of fatal to EF's argument on that front was the fact that these sort of highlights had been suggested by the very career counselors that EF had hired to advise Mr. Conklin on how to best put his face forward. So the court said, well, you can't really complain about that when that was your people who suggested that he do that. And overall, we think that those comments were innocuous enough. We're not going to hold World Strides or Mr. Conklin responsible for anything there. Now, the court did critique the fact that Conklin had reviewed the severance package. It did find that he should have properly declined to review that package for the EF employee. But under the circumstances, the court said, well, his comments were kind of common sense. And there was no evidence led, unfortunately, for EF that his comments did any damage to EF in any event. So essentially, no harm, no foul. And as a result, the court decided to grant summary judgment to World Strides with costs to World Strides. And our takeaway from this case is really that, if a covenant is substantially complied with, the court's not going to be interested in technical or kind of de minimis breaches. So that takes us to our third case, which is Citywide Towing and Recovery Service Limited versus Pool. This is a 2020 case from the Alberta Court of Appeal, heading west here. Leave to this appeal to the Supreme Court of Canada was sought and refused in 2021. And I've included this case because it squarely addresses the use of the legal doctrine of severance, also known as blue pencil severance. And it goes in a bit of a different direction than most of the other case law out there. Now, I'm sure at some point the courts must have had blue pencils. I feel like they should keep up with the times. It should probably be red pen severance because that's what we do these days. But at any rate, historical reasons, it is called blue pencil severance to this day. The other change here is our first two cases were in the employment context. This one has a little more of a commercial flavor. So the covenant at issue in this case was found in a non-competition agreement. And so let's have a look at that covenant. So the vendor shall not, at any time during the period commencing on the date hereof and ending on the date that is 5 years from the date of this agreement, solicit either on the vendor's own behalf or on behalf of the partnership, or jointly or in conjunction with any person or entity, directly or indirectly, in any of these different capacities, be engaged in, concerned with, advised in, advise, lend money to, basically don't do anything with anybody else who's competing with us in the non-compete area. Now, the non-compete area was defined in another section of the agreement to be Alberta, Saskatchewan, and British Columbia. And again, because all of these covenants are considered sort of within their factual matrix, I'll give you the facts of this case. So the defendant, Devon Poole, was the owner of Capital Towing, which was a vehicle towing business operated in and around Edmonton, Alberta. And if I could just have the next slide with the facts there. 2017, Mr. Poole sold the assets of Capital Towing to Citywide Towing and Recovery Service for $700,000. And in connection with the sale, Mr. Poole entered into a non-competition agreement, which contained the clause that we just looked at. And he also stayed on with Citywide as an employee. About a year later, he decided to resign from his employment with Citywide, and he immediately took up employment with one of their competitors, DRM Recovery. Now, Citywide, took offense to this. They applied for and they got an interim injunction, which prohibited Mr. Poole from competing with them. Now, on appeal, Mr. Poole and DRM were, in the usual course, working together, and they argued that the restrictive covenants were unenforceable, that they were overbroad, and they were in restraint of trade. They argued that the non-competition covenant should have been limited to the territory where Capital Towing actually did business at the time of the sale. So that was in and around Edmonton. And they argued that Citywide had no legitimate interest in restricting Mr. Poole's activities in BC and Saskatchewan because, well, it didn't even do business there. So on appeal, it was heard by a panel of 3 judges, and all 3 of them, this is where it gets interesting, all 3 of them decided, yes, this non-competition covenant is geographically overbroad. It's actually unreasonable. Capital Towing hasn't done business outside of Alberta, so we think it's unenforceable. However, the majority of the Court of Appeal was prepared to use this older doctrine of notional severance or blue pencil severance to fix it. And essentially what that doctrine, what a court does if they're using that doctrine is they just take their pen and cross out the parts that they don't like. And so the majority decided that they would cross out the words BC and Alberta. And in doing so, they narrowed the geographical scope of the covenant to those operations in Alberta. And they basically said, okay, once we've taken those out, then this non-competition clause is going to be fine. So essentially, they've kind of fixed the problem. We could just have the next slide summarizing the majority and the dissent. This was kind of a surprising decision because there's a significant amount of case law at the Supreme Court of Canada that really says courts should not be doing this. They should not be rewriting terms for the parties. But the majority was alive to those cases and they did look at them, but they weren't concerned because they said those cases are distinguishable because they were focused primarily on employment relationships. And it's clear that the majority was quite comfortable using the doctrine in this case because it was in the context of a commercial relationship where there was no imbalance of power. Now, the minority, which was Mr. Justice Slattery, strongly disagreed. And he said, you're not applying this doctrine correctly. We're only supposed to use the blue pencil severance for minor or for trivial matters. The covenant was far too broad, and crossing out, British Columbia and Saskatchewan is not a trivial change. And therefore, the blue pencil sort of doctrine should not have been used. And he found that his holding was that this remedy that the majority had agreed to removed any incentive to exercise care in drafting and essentially would just promote litigation like this. And I think that you can sort of see the tensions there in these commercial cases. On the one hand, it didn't really seem fair when this gentleman had kind of left and was competing, but the clause was really overbroad. And so the majority was prepared to sort of fix it and kind of do that high-level justice. And the minority said, well, no, you're stretching this doctrine, really beyond where it's supposed to be used. Now, our next slide just highlights at a very high level and kind of more for your reference than anything else, a couple of commercial cases from the last year. And as you'll see in both of those, the restrictive covenants were in fact upheld. So we have the Ruel case, which was a 5-year non-compete, again, in this sort of business commercial perspective, and Diamond Delivery as well. Also, a longer compete upheld in the business kind of context. The 5-year term, in the employment context, I would bet you would almost never see that being upheld. You'd have to have really unique facts, but longer periods can be accepted in this commercial kind of environment. So that takes us to the final case that I'd like to share with you today. And this one is ADP Distributors, Inc. And this case involved the enforcement of what are called waterfall non-competition clauses in an employment relationship. So the non-competition clause had a temporal scope, and it was drafted in such a way that it could range from 12 months down to 3 months. And it had a geographical scope that could range from 150 kilometers to 35 kilometers. And I've provided an example in the next slide that shows the section dealing with the geographic scope. And as you can see, it specifically sets a radius from the principal places of business. But then it says, well, but if that isn't reasonable, let's try X instead. And so these kinds of clauses or this style of drafting, explicitly invites the courts to take out their blue pencils. The employment contract also included, as we'll see on the next slide, a non-solicit clause, which read that the employee agrees for a period of 12 months from the date of termination of the employee's employment, however caused, the employee will not solicit or accept business with respect to products competitive with those of the corporation from any of the customers, agents, or others of the corporation as of the time of termination of the employee's employment, wherever situate. And the facts of this case were as follows. Mr. Davidson was 57 years old. He lived in Surrey, BC. And as we'll see on the next slide, he started working with ADP in the parts and engine division. He was a parts person, and he worked his entire working career, over 39 years, in the engines and engine parts business. ADP also distributed products other than engines and engine parts, and so that is important to kind of keep in mind when we look at what the court did here. And essentially, after some time, he'd been employed, the parties entered into a written agreement, which included the clauses that we just looked at. And there was no issue about whether the agreement was enforceable because of a lack of consideration. That can sometimes be a challenge when you're implementing contracts sort of midstream. But that wasn't an issue. The court was really just focused on, is this language of the covenant enforceable or not? So in 2017, the ownership of ADP changed. Mr. Davidson became dissatisfied for a number of reasons. And on July 11th, he resigned from ADP. Very shortly thereafter, he started working for a competitor, and he didn't try to deny that he was calling on the very same clients that he'd worked with during his time at ADP. The other thing that was important about this case is there was really clear evidence that his efforts were incredibly successful. So as soon as Mr. Davidson started working with those clients, ADP started losing that business to the new employer. So ADP, understandably upset, went to court to try to enforce its restrictive covenants. And the court ultimately refused to do that because it found that the covenants were unenforceable. It accepted Mr. Davidson's arguments and found that the clause should be struck down because, first of all, it was not clear as to what was meant by the principal places of business. Mr. Davidson worked out of one office. There was no kind of, in the factual matrix, an obvious sort of series of office spaces that were the principal places. And so we go back to Matt's refresher, nobody really knew, Mr. Davidson really couldn't know what were supposed to be these principal places of business that this sort of restrictive covenant's geographic scope was kind of arranged around. So that was the first problem. The second problem was, even if there were kind of these principal places of business, Mr. Davidson only worked out of the one office, and there was no evidence led as to why ADP needed to keep him from working in these other areas as well. And finally, the court in this case was not inclined to pick up its blue pencil. So it did not want to go down this whole waterfall of well, if this isn't enforceable, then let's try this and kind of go through that waterfall analysis. The court stuck with, okay, we're just going to go with the 150 kilometers that you started with. And ADP, you really haven't shown us why that 150 kilometer radius is at all reasonable. Now, in this case, the court not only refused to enforce the non-competition clause, but it also decided to not enforce the non-solicitation clause. And as we heard earlier, generally speaking, non-solicits are a little bit easier to uphold. But the rationale with the non-competition clause was as follows. So first of all, same problem as the non-competition clause. ADP hadn't shown any reason why it needed to restrict Mr. Davidson from selling anything other than engines or engine parts. That was the only thing that he had done for them. And so it wasn't necessary to protect ADP's business to restrict him from selling other kinds of things. The second sort of fatality to this termination clause was that the non-solicitation clause, the court said this is not actually a non-solicit. This is a non-competition clause in disguise. It doesn't just prevent him from going after those customers of ADP, but it also prevents him from accepting business from those customers, even if they've come to him. And in that case, because it was interpreted with that sort of stricter lens that the courts use with the non-competition clauses, they found that it was overbroad and unenforceable. As a result, ADP was out of luck, and Mr. Davidson got to continue competing with ADP and soliciting its clients. So our takeaway on that one is make sure you have really clear and cogent reasons as to why you need a particular restriction. Keep the drafting simple and be really careful to tailor your clauses to the particular employee and role in question. So those are our 4 kind of in-depth cases for today. Now I'm going to turn things over to Anthony to talk to you about the trends that we're seeing both across Canada and the USA. Over to you, Anthony.
Thanks, Elizabeth. So I think the cases that we've discussed provide a pretty good sense of the trends that we're seeing across Canada. And as Matt touched on earlier on in the presentation, the starting point is always that, at least in the employment context, that restrictive covenants are presumptively unenforceable, and it's up to the party who wants to enforce them to convince the court that the covenants are reasonable, that they're clear, and that they should be enforced. In terms of trends, we're seeing that, just generally speaking, courts are reluctant to enforce provisions that limit employee rights. And I think this is especially so in Ontario compared to some of the other provinces. Just to take a step out of the restrictive covenant context for a minute, when we're dealing with termination clauses on a very regular basis, and when you're looking at termination clauses, I can't think of a case in Ontario in the last 4 years where a court has enforced a termination clause, and where in the cases where they were enforced, they were overturned on appeal. There might be a case in the last 4 years, I'm just not aware of it. That's how many cases there are where courts are striking down clauses that limit employee rights. And so that's the lens in Ontario, and we're seeing a similar perspective when it comes to restrictive covenants, and that's been the case for many years at this point. Outside of Ontario, so we'll turn to British Columbia first. We've seen from some of these cases that the courts in British Columbia, the general principles still apply, but the courts are willing to enforce restrictive covenants that are properly drafted and are not overbroad. In Alberta, we're seeing a similar approach. The recent case, the Court of Appeal case that Elizabeth summarized, the citywide towing case, a bit of a unique case, somewhat of an outlier, taking a somewhat different approach. Historically, those courts would not blue pencil or even strike out words. They would just look at the entire section, just strike out that entire section, not try to make it enforceable. If it was overbroad, they would just strike it out and the clause itself would be unenforceable, as opposed to striking out particular words to make it enforceable. So a bit of a unique case. It'll be curious. I'm curious to see how that is applied in the future, whether the lower courts will find ways to distinguish it, or whether they'll happily apply it. But if we turn to Ontario, so again, the courts in Ontario seem to be more reluctant to enforce restrictive clauses or clauses that limit employee rights. And in terms of in the context of restrictive covenants, or especially non-competes, historically, whenever I've thought about non-competes in Ontario, I've always thought about the case where you have a dentist who sells his practice and goes and operates another practice 2 kilometers away. And the restrictive covenant says that the dentist will not operate another dentistry practice within 10 kilometers in the next year. That's the type of clause that you see litigated. Or another example might be a martial arts instructor who goes down the street and opens a new karate studio, and all of his students follow him over there. That's the type of case that I think of when it comes to non-competes in Ontario. Now, all types of employers historically have used non-competes, have included them in their contracts. You don't see them litigated very often, and when they are litigated, it's very frequently courts will find some reason to not enforce it or find that the clause is ambiguous. And just to give you some examples, we touched on some of the language earlier, but one example might be we were talking about the supermarket test, where the non-compete prohibits the employee from working for another competitive business in any capacity. Well, do you really have an interest in ensuring that the employee does not work for a competitor in a completely unrelated capacity? Cutting meat at a deli counter when they were working in a pharmacy beforehand, and that's where your business is the pharmacy industry, not the grocery business. So that's one example. Courts, the clauses that we see often say the employee shall not compete in any capacity. Or we'll see clauses that say shall not be involved in any competitive business. Well, what is competitive? Does the employee know if the business that they were about to engage in is competitive? So the courts will say that's ambiguous. Or sometimes we'll see clauses that say concerned with. The employee should not be concerned with. Well, what does that mean? Another example might be clauses that say shall not compete with the company or its affiliates and subsidiaries. And if that employee didn't work for an affiliate or subsidiary, how is the employee supposed to know whether they are going to be breaching the clause when they're accepting, employment or soliciting clients from a business that is an affiliate or subsidiary that they don't know? So these are some examples, and I can keep going on and on for an hour. In short, there's an entire laundry list of arguments that you can make when it comes to restrictive covenants in Ontario based on all the case law we've seen. That's not to say that courts will not enforce them in appropriate cases, or especially in a sale context. We see that courts are more willing to enforce clauses in that context. But that brings me to the comment that I have here on the slide. What I've been speaking to now is restrictive covenants before October 25th, 2021, and especially non-competes before that time period. And the reason I say that is because back in 2021, the government of Ontario implemented a ban on non-competes in Ontario. And they implemented it by amending the provisions of the Employment Standards Act. So there is now a clause or a provision in the Employment Standards Act that says no employer shall enter into an employment contract or other agreement with an employee that is or includes a non-compete agreement. So it's an outright prohibition on those agreements. In short, employers are not allowed to enter into any type of agreement that contains a non-compete agreement. And the Employment Standards Act specifically defines what will amount to a non-compete agreement. That definition sets out exactly what will be considered. But before I get into the definition, I just want to emphasize a distinction that we've touched on earlier. And it's the distinction between a non-solicitation clause and a non-competition clause. Non-solicitation clauses, as Matt was talking about earlier, they're aimed at preventing an employee from taking advantage of pre-existing relationships and soliciting, for example, former clients who, because of their pre-existing relationship, will be able to get their business by contacting them. Non-solicitation clauses don't prevent employees from generally working in the same industry, and they don't even prohibit employees from doing business with former clients. It's as the name suggests, soliciting that is the purpose of these clauses. Non-competition clauses, on the other hand, they go the extra step. They're broader, and these will capture activities that wouldn't be captured by a typical non-solicitation clause. So the reason I'm emphasizing this is because the ban in the ESA deals with non-compete agreements, non-competition. It doesn't address solicitation, doesn't impose a ban on non-solicitation clauses. But very frequently, what I see is I'll get a contract and you look at at the clause at issue, it's labeled non-solicitation, but then when you read the actual content, the actual prohibition in the contract, it goes beyond solicitation. And so, for example, it might say something like the employee shall not solicit or otherwise accept business from clients. And if you're accepting business, courts have viewed that as a prohibition or a restriction on competition, not solicitation. So even though you might have a clause that's labeled non-solicitation, it might still be captured by the new provisions in the ESA because it goes beyond solicitation and falls within a non-compete agreement. So all of that said, let's look at the definition of a non-compete agreement here. And I've put up the actual language on the slide, but I've broken it down just to make it a little bit easier to digest and to see the different components of the definition. So the first piece is a non-compete agreement is an agreement or any part of an agreement. So an agreement will be an agreement that is specifically or dedicated to dealing with competition, might be a non-competition agreement itself. And then the second piece is any part of an agreement that would capture, for example, an employment contract that has a non-competition clause in it where the employee agrees not to compete. A non-compete agreement has to be between an employer and employee to be captured by this prohibition. So if it's an agreement between if it's an agreement between one company and a person who is a legitimate independent contractor, and I say legitimate in the sense that it's not just an employee who has signed a contract or agreement and has been misclassified. So those wouldn't be captured. If they are misclassified, they'd be captured here. But if it's a true independent contractor, they wouldn't be captured by this. A non-compete agreement is an agreement that prohibits the employee from engaging in any business, work, occupation, profession, project, or other activity that is in competition with the employer's business. I think that speaks for itself. And then the last piece here is that the agreement is an agreement that prohibits those activities after the employment relationship ends. So if it's a clause that simply says during the employment relationship, the employee agrees not to compete with the employer or engage in any outside business, that wouldn't be captured here. But it would capture clauses that apply afterwards. And so there are exceptions in the Employment Standards Act, exceptions that are specific to the prohibition on non-compete agreements. The first specific exception is an exception for employees who hold the office of a C-suite position. And I use the phrase C-suite position to summarize the exception, but the exception is specific to the positions that I've listed here. It's not necessarily anything that could be qualified as a C-suite position. It has to be one of these positions that are listed on the screen, or it has to fall within the sort of catch-all or the basket clause at the end, any other chief executive position. Now, we don't really have any guidance on how these exceptions or these positions will be interpreted, but essentially it has to be the chief executive officer, which is typically the highest level position in the company, or the next row below in the organizational hierarchy. That's what it looks to be capturing, but time will tell once we see some cases out there that provide some guidance. Another exception that we have is an exception for the sale context. And again, I put up the slides and I've broken it down. So the exception applies where there is a sale of a business or a part of a business. And in order for the exception to apply, there has to be an agreement that's entered into by the purchaser and the seller as part of the sale. And so it's critical here that the agreement has to be between a purchaser and the seller. The agreement has to prohibit the seller from engaging in any business, work, occupation, profession, project, or other activity that's in competition with the purchaser's business after the sale. And then again, an even narrower or another limiting phrase here is that in order for this exception to apply, the seller must become an employee of the purchaser immediately following the sale. And if they don't, then this exception doesn't apply. So it's a very narrow exception, unfortunately. Again, we have very little guidance on this. It doesn't appear to have been litigated. Time will tell. Hopefully, the Ministry of Labor will provide some guidance on how they interpret it. Hopefully, the courts will see some cases coming out in the courts. But for now, we're sort of left to deal with past cases and just the general understanding that exceptions are interpreted narrowly because they are the Employment Standards Act is an act that's there to protect employee rights, and so any exception is going to be interpreted with a narrow lens. Before I move off on to talk about trends in the United States, one other point that I wanted to raise here is that these are the two exceptions that specifically deal with the non-compete agreement provisions, but there are exceptions to the Employment Standards Act generally. So if the Employment Standards Act does not apply to the person at issue or to the relationship at issue, the prohibition on non-competes also doesn't apply. So there may be other exceptions that will get you out of this whole scheme, but keep those in mind. I think that would take us beyond the scope of today. So I've left them, but I just wanted to flag that to keep in mind as sort of an additional argument that you could have in your back pocket. In terms of trends we're seeing in the United States, courts are often refusing to enforce covenants except for executives or in the cell context. The Workforce Mobility Act was reintroduced last year, and if it's passed, it would effectively ban employers from entering into non-compete clauses with workers, including contractors, and it would require employers to rescind existing non-compete covenants and inform their workers that the covenants are no longer in effect. So I'm not a specialist in a lawyer in the United States, so I'll leave that further insight to specialists in the States. But in terms of what we're seeing again some progress as well in the United States in terms of unwillingness to enforce or allow these types of clauses. And just before we move off to the topic of enforcement, I thought I'd conclude by giving some general practice tips, summarizing what we've already talked about. It's critical to make sure that these clauses are customized and they're not boilerplate. If, for example, the clause that's provided to you or that's drafted for the initial draft refers to the employer's premises, like we saw in the case earlier, it's important to make sure that that language is tailored so that it applies and is suitable for your business, for your structure, for your organization. It's important to make sure that it's clear and unambiguous, and again, reasonably limited in terms of activity, temporal scope, and geographical scope. And I know some questions have come in asking about how these interact with each other. And it's not, if it's extremely narrow when it comes to activity or extremely narrow when it comes to geographical scope, that's not going to offset deficiencies in any of the other areas. So all three have to be reasonable in their own right. And then when you're making sure that the clause is reasonable and clear, you want to make sure first you want to start with the entire clause itself, because you might look at one piece, but there's again another part of the clause that elevates it to a non-compete if it's a non-solicit, or you might have terms that are in one section it's capitalized and in the next part it's not capitalized. You want to check the definitions that are referred to in the clause itself to make sure that those are consistent, to make sure that those definitions are reasonable. And then you also want to review the remainder of the agreement because you might have inconsistent or contradictory clauses elsewhere. So keep those in mind as well. And with that, I'll turn it over to Elizabeth to talk about practical considerations when it comes to these clauses. It's not all doom and gloom, but she'll give you some insight there.
Thanks, Anthony. So for the final part of our presentation, we wanted to take just a bit of time to talk about what your enforcement options are. We'll go briefly through some of the options you might want to consider if you find yourself with a competing employee or vendor, and then talk about some of the important factors to consider before you take any action. The most amicable resolutions are kind of based in relationships, and essentially I'm going to go from kind of perhaps least aggressive to the most aggressive from a legal perspective. Literally, sometimes all it takes is for one CEO to call another. You may be able to get agreement that the other party will comply with the covenant as it is. You may end up with negotiating kind of a trade-off with either respect to the length of the covenant or the spatial restriction to get something that both parties can live with. And sometimes it can even make sense to try to convince the new business to buy a specific book of business outright in order to avoid the dispute. And that last option I've seen a number of times in the insurance industry in particular. A broker will move from one shop to another, and rather than fighting over the new employee's non-solicit or non-compete, the business teams come to an agreement that the new employer will just pay for any clients that come over, based on a reasonable multiple. So that's kind of like one of your sort of first levels is, look at the relationships you have. Is there anything that can kind of be done just through talking through the issue and through the dispute? Now, your next option is your classic cease and desist letter. Varying levels of kind of aggression within that category. As a first step, you might start with a gentle reminder from the company and escalate from there. Or you might go straight to something from counsel that ends in govern yourself accordingly right away. On our next slide, under the heading of litigation or kind of more formal proceedings, I would include, both lawsuits as well as alternative dispute resolution, such as a mediation or arbitration too. And, those things can be taken kind of independently, or, we'll often see a bit of a combination where litigation will be started, and then the parties will move to some kind of alternative dispute resolution to try to get it done and get the dispute resolved. On its own, a lawsuit is fairly easy and quick to commence. And unless you're taking kind of additional steps, like the injunctive relief we'll talk about, it's not overly expensive to start, depending a little on the complexity. But then, of course, it's a little bit of how far do you want to go to kind of to take your message on. Obviously, if you go all the way to a full hearing, examinations for discovery, depositions, document disclosure, and a lengthy trial, then it does get very expensive. Now, if you really kind of want to show that you mean business, you can consider an application for injunctive relief. When it can be obtained, injunctive relief is highly effective, as you'll have a court order stopping that rogue employee or vendor from doing things like soliciting your customers, using your confidential information, and in rare cases, sometimes competing with you at all. The challenge with the injunctive relief is that it's very difficult to get. And in order to get an injunction, there's sort of a classic test, sort of three-part test that you have to kind of meet all of the elements of. And the first element, depending on exactly what you're trying to do, there can be some nuance, but essentially you have to convince the court that there's a serious question to be tried or that you have a strong prima facie case. So you have to be able to tell the court, we're coming in and this really is a matter of considerable concern. And we are likely to do very well, should this matter go further. The second part of the test, you have to show that you will suffer irreparable harm if the injunction's not granted. And then the third part of the test is you have to demonstrate that the balance of convenience favors granting the injunctive relief. And so under this part of the test, the court's going to consider sort of the overall impacts of what happens if the court grants the relief and what happens if they don't. And they're going to consider the impacts not just on the parties themselves, although that's usually the primary consideration, but they're also going to look at whether there are any third parties or kind of innocent bystanders who are going to be impacted if this injunction is granted. And in the restrictive covenant kind of world, injunction applications often fail on one of the first two prongs of the test. Either the court finds that the covenant is not enforceable, and so the applicant doesn't have a strong prima facie case in the first place. Or even if the covenant is enforceable, the court's satisfied that any harm is not irreparable, and it could be addressed with an award of damages. Now, there are a few different kinds of injunctions that you can look at getting or consider. One is an interim injunction. And that's an injunction usually measured in days. It's designed to preserve the status quo when there's a serious risk of harm from a competitor's activities. Very short, in very extreme circumstances, it can be obtained ex parte, which means without notice to the other side. If the court is satisfied that providing notice might result in either increased kind of bad behavior or the spoliation of evidence. Those ones for a litigator are incredibly exciting because you literally go up to the courthouse and you tell them, I don't care what else is on the docket. This has to be heard. It has to be heard today. And we need this injunction right now. And no, we're not even going to tell the other side what we're doing. As you can imagine, in order to kind of, you can only really get away with that in the most extreme circumstances, but definitely very exciting when you do. And, of course, as soon as you have that court order for your interim injunction, you have to serve it on the other side. And then you get very, very busy because they're usually caught quite flat-footed. That's extreme circumstances. So you're not going to be doing that every time for sure. In fact, it's quite rare that we need to take that extreme an action. More commonly, notice will be given to the other side, but sometimes it will be given just hours in advance. So that's sort of like the interim injunction. That's sort of the immediate, okay, let's just put a pause on things. The interlocutory injunction, that's a longer term injunction, which is sort of designed to preserve the status quo for a more significant period of time until the matter can be heard. That one is usually done on notice, often in chambers. And then finally, a permanent injunction, that's one that stays in place forever. So those are much less common, but they can be appropriate where, for example, there's a significant risk of the use of confidential information by a defending party. Now, the downside of the injunctive relief is, while it is incredibly useful if you can get it, not only is it very, very difficult to get, but depending on what's happened and the number of parties involved, it can also be extremely expensive. So that sort of takes us to some of those key things to think about when you're looking at your enforcement options. The bullets are fairly straightforward, but I'll perhaps highlight for you the last one. When you're in a position where you have to start considering any of these options, there's often sort of a lot of heightened emotion around these kinds of cases because of whatever's happened. There are feelings of betrayal or injustice. Sometimes the person who's now competing with you, might have been a good friend. You might have worked with this CEO for the last 20 years, and all of a sudden, they've defected. And there can be a lot of anger. We negotiated this, they agreed to it, and now they're just, walking and doing exactly what they said they weren't going to do. And quite frankly, people's feelings can be really, really hurt. So, those emotions are I find often there, and they kind of need to be worked through, but it's really important that they don't cloud the decision-making process, because, the initial, response is often like, let's go do this and let's take it and I don't care, money's no object. And, that may be appropriate, but you want to be really careful that you're considering, what's the business case between the action that we're deciding to take. And so the kinds of things that I encourage clients to consider when they're looking at these different enforcement options, their first one is sort of how dramatic or how strong is your case, and what evidence do you have to prove it? So, where you're pretty sure that something's happening, but you don't have a lot of evidence, the court's not going to pay a lot of attention to you. If you can show, okay, these 10 employees, they all just left en masse, they gave us no notice, and we have clear evidence that just before they left, they've been emailing home their confidential information and making arrangements, to start soliciting our clients, then you might be quite well justified in going to take a more extreme approach, because you've got that evidence to go to the court and really convince them that this is a problem. Because they're not going to do anything based on speculation or kind of a gut feeling, even if that gut feeling is accurate. You've got to have that evidence. The next factor is kind of, what's that actual impact of the breach? So it might be aggravating, it might be annoying, but if this is a small potatoes person or the breaches are fairly tiny, think about that EF case that we looked at earlier, you're probably not going to want to put a ton of resources into that. You always have to consider, the risk of disclosure of confidential business information to your competitors or to the general public in the course of the litigation. That can be a risk. There are things that we can sometimes do to kind of mitigate that, but it's always an important thing to consider. You've got to look at the costs involved. And I always encourage people, don't just look at kind of the money and the legal fees, but think about the management time, because it may not be a good time in your business to have your senior people, sitting in a room with me, going over their affidavits and going over, preparation for the injunction, when there is a core kind of business activity that is then being neglected because they're spending all their time on this injunction. The other factor that I encourage people to consider is kind of what reputational interests, do you have in respect of whatever's going on? So do you need to take a strong stance to discourage this kind of behavior? Or is it more, in the employment context, some clients are more concerned about avoiding any perception that they might be bullying their former employees or somehow kind of being the giant going after this tiny little employee who really isn't, harming them that much. So those kinds of reputational things can play in. And of course, you always have to think about what happens, if we're not successful, because as we've seen, particularly in the employment context, that is a significant risk. And in your worst case scenario, you could find that your standard form contract, is not worth the paper it's written on. And now if you have, hundreds of employees on that same contract, anyone who's disgruntled and currently working with you, knows that that's not enforceable, and your competitors know it too. So that's a significant risk. So hopefully that gives you, some of the ideas of things you should be thinking about when you're considering those enforcement options. That brings our prepared remarks to a close, and now we have some time for Q&A. So I will turn things over to Matt, who's going to be our moderator for the Q&A session.
Thanks, Elizabeth. So yeah, we have about 15 minutes for questions. We had some come in prior to the presentation and some throughout the course of the presentation. So we'll try to answer as many as we can here. This is a question for Anthony. How likely is it that an employment contract in Ontario that has a non-compete that is qualified by language to the effect that the provision only applies in the event that the person is a C-suite employee as defined by the ESA? How likely is that to be upheld?
Well, again, we haven't seen any cases, or there isn't really any guidance, so this is sort of just speculating. But based on what I've seen, even in terms of termination clauses, there's termination clauses that say we can terminate without any notice, except, or we can terminate for just cause without any notice, except to the extent required by the Employment Standards Act. And there was at least one case where the court said, we're not going to enforce that type of clause because we're not going to allow you to include language that tries to contract out, but then tries to correct it at the back end. So the type of clause we're talking about here sounds to be similar, where it says you can't compete except to the extent that an exception applies. I think if you're going to be including clauses, you should try to draft it so that it doesn't fall within the scope of the prohibition to begin with. And I think if the position that's on the contract, for example, if clause number 1 or clause number 2 says you will be employed in a role, and that role that's listed there is not one of the roles in the ESA, that's a C-suite position, or is not another chief executive position, I'd be surprised if the court found that the exception applied in those circumstances.
Okay, thanks. And this is a question for Elizabeth. In the M&P Drug Mart case, the nature of the work that was restricted by the clause was very broad. However, the geographic scope was limited to within 15 kilometers, a 15-kilometer distance. Was that limited geographic scope considered by the court in its analysis?
No, in that particular case, the court really didn't do that kind of balancing exercise to say, that the court just found that the overbreadth was fatal. And I think they would have found that, reading the case, based on, regardless of how far the radius had been, whether it was 5 kilometers or 100 kilometers, that overbreadth was really what was crucial to kind of having that covenant struck out.
Okay, great. And then this is another question for Anthony. In light of recent amendments to the Competition Act, are unilateral non-solicitation clauses still enforceable?
So the answer is that if it's a unilateral non-solicitation, it wouldn't be captured by the new provisions in the Competition Act. The Competition Act prohibits agreements between unaffiliated employers to not solicit or hire each other's employees. So it has to be an agreement between two employers, and the agreement has to be that they will not solicit or hire each other's employees. If it's just an agreement by one employer not to hire the other's employees, it wouldn't fall within that. Now, a couple of things to be careful with. First would be you might have a unilateral agreement flowing one way and later enter into another unilateral agreement flowing the other way. And I'm not a competition law expert, so I don't want to say one way or the other for sure, but it wouldn't surprise me if those two agreements were considered together. So if you're entering into unilateral agreements, think about whether the provisions in the Competition Act could be triggered if you were to enter into an agreement flowing the other way, and whether that type of agreement is likely to occur at some point in the future. And then the other thing to keep in mind is if you're using contractors, for example, a true independent contractor might be considered an employer in their own right. Typically, independent contractors have the ability to hire their own employees to do the work for them. And so if you have a non-competition agreement or a non-solicitation clause in the contractor agreement, you might find yourself in that situation as well. So just some cautions to keep in mind. But all to say, if it's a unilateral non-solicitation clause in your standard employment agreement, it's probably not going to be an issue.
Great, thanks. Another question for Elizabeth. What criteria would go into and how would an employer draft a reasonable geographic scope in a restrictive covenant for a business that has employees across the US and Canada?
That's a great question. And that is where it gets really complicated, because on one level, the law hasn't entirely caught up with things like remote work or sort of like widely distributed kind of businesses. So, I mean, I would say what you've always got to look at is, for these employees, like who do they have access to? So you might be able to justify, even a Canada-wide restriction if the employee is kind of based in one particular place, but is dealing with customers all across the country. But if they're only dealing with, if they're in a specific division or a subdivision or a department of the organization, and they're only dealing with, for example, the clientele in Quebec, the court's going to say, well, no, you can't stop them from competing in other provinces. You don't even do the business there. Of course, unless you're in Alberta, when you might get those blue pencils out. But generally speaking, the safest thing to do is always to really look at, what are these employees doing, and what are we trying to prohibit them, or what roles are we trying to prohibit them from taking in another business. So sometimes you can limit it that way by looking at, what's the particular role. Like for the example, the pharmacist, okay, we don't care if you go and work for a competitor, as a salesperson, because we know you don't have any special knowledge of our business to do that. But we don't want you to go work for them as a pharmacist, because that really would hurt our business.
Great, thank you. And another question for Anthony here. How would an employer implement a non-solicitation or non-competition clause where there was no special consideration for that clause paid by the employer, and where the employee's salary in connection with the employment for which such a clause exists is at a market rate?
If you're if you're an employer who's trying to implement a non-solicitation clause, I always would advise giving some kind of consideration. Amount of consideration.
That's the same in British Columbia as well. You would need that consideration, and if you don't have it yet, then you've got to figure out a way to kind of re-implement the agreement using the consideration to make sure that it's not going to be struck out on that basis.
Yeah, exactly. And I think in terms of consideration, the case law is not the clearest. There, you have the traditional line of cases that's saying a peppercorn is enough consideration. So essentially nothing, as long as it's something that is of the smallest value, that will be enough. But you have other cases where the courts will say, well, you asked the employee you said you'd give the employee $10, but then you also say in the same agreement that employee will give you $10. So really they're getting nothing. Or there's cases, there's a case I think that it said the consideration was the employee's annual salary increase, but the employee would have gotten that anyways. So really you weren't giving them anything new that they wouldn't have otherwise gotten. So it can be a little tricky, but yeah, it's important to find some way, whether it's a signing bonus or whatnot.
Great. And question for Elizabeth: What are the considerations that an employer should be thinking about when drafting a non-competition or non-solicitation agreement or clause for executives versus non-executives?
I think the key difference is that the courts are going to be a lot more worried about the more junior employees, the non-executive employees. So you're probably only going to get away with, you're probably going to have to look at and again, it's always going back to, what's reasonable in the circumstances. So if you're a junior employee, who only has access to a very limited amount of information in a very specific area, you may not be able to uphold a non-compete against them at all. Whereas, your executive who's going to have, much more seniority, they're going to have access to a lot more information. They might have high level connections with the customers, for example. You can probably the courts can see the kind of damage that sort of person can do. So they're more likely to kind of uphold restrictions against those more senior people. So it's really about kind of tailoring it to the individual. So I would look at things like, what level of information do they have? How long is it going to take to replace them? If you say we need to take this, junior receptionist out of competition, for the next 2 years, well, there's no way that's going to get upheld because it's just not going to damage your business. If you can say, we've got this salesperson and it's going to take us 6 months to replace them, and that's why we need 6 months, and you've got some evidence for that, you might be able to get away with that. What I encourage clients to do is really think about, okay, if I have to take you to court and we're trying to uphold this clause, we don't want to say like, oh, that's just what the lawyer put in there. You want to be able to say, this is why this particular rule needs this particular kind of clause, looking at the scope of what the person does, their level of authority and kind of influence with the business, the kind of information that they have access to, the customers that they work with, all of those kinds of things. Now, practically speaking, are you going to be doing that for like every single, junior employee? If you're a very large organization, probably not. You're probably going to go with something broader and hope that it will be enough of a deterrent that even if it's not enforceable, it might make people think twice before competing with you, and save kind of the big guns or the really careful drafting, for your CEOs who are generally going to be, more damaging if they're competing or soliciting your clients in any event.
Great. And maybe just time for one more question here. Anthony, or I guess this could be for both of you. Do you have any particular concerns with listing out specific competitors in a non-solicit or non-compete clause?
It's been a while since I've seen a clause drafted like that. I haven't drafted a clause like that. It's also, you might also run into issues where that that business that you've listed has multiple lines of business, which are not necessarily competing with the business that you're running into. So if you're just listing it based on the corporation name as opposed to the actual business that you're in, you could run into some issues there.
Yeah, I would say the same. There we go. All right. Well, thank you for moderating our Q&A there, Matt. It looks like we've come to the end of our time for today. So I'd like to thank everyone who tuned in today, and of course my fellow speakers for being here with us. On your screen, you'll see 2 QR codes. One is for our survey, and the other is for the Ontario and Quebec CPD certificates. Links to both of those have been added to the chat as well. For our BC viewers, the Law Society of BC title has been added to the chat too, so you can find that when you log in to record your CPD credits. We do have an upcoming, another LAHR webinar coming up on May 7th. That one is called Supporting Transgender and Gender Diverse Employees in the Workplace, accredited for those ever valuable EDI credits in Ontario and Professional Responsibility and Ethics in British Columbia. So if you want to make sure you're getting your credits for those, we encourage you to tune into that. You can register through the link in the chat, or you can visit the Fasken Institute section of fasken.com. So thanks again for coming, everyone. We hope you have a great afternoon, and thanks for being with us.